Here's my fancy. Here we go. This time we will call the order of the Criminal Justice Public Safety Committee. As the chair of the Criminal Justice Public Safety Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic, and in accordance with House Rule 67 and the governor's emergency order number 12, pursuant to Executive Order 2020-04, this public body is authorized to move electronically. This is a public hearing on bills referred to the committee and scheduled in the House calendar for today. An executive session may be held on any bill referred to the committee. Please note that there's no physical location for members of the public to observe and listen contemporaneously to this meeting. However, in accordance with the emergency order, I confirm that all members of the committee and select legislative staff have the ability to communicate contemporaneously during this meeting through the Zoom electronic meeting platform. And the public has access to contemporaneously listen and, if necessary, participate in this meeting by the Zoom platform or by telephone. All necessary access information has been made available in the House calendar and through the electronic calendar of the General Court website. The notice of this meeting complies with House Rules and RSA 91-A. Anyone who has a problem accessing the meeting should call 271-3600 or email hcs@leg.state.nh.us. In the event the public is unable to access the meeting will be adjourned and rescheduled. Please note that all votes that are taken during the meeting will be done by a roll call vote. Let's start the meeting by taking a roll call attendance. Each member states their presence. Please also state whether there's anyone in the room with you during this meeting, which is required under the right to know law. Clerk will now call the roll.
Vice Chairman Welch.
Here.
Representative Bob Green.
Here in the room.
Representative Hopper.
Here.
Representative Dennis Green.
Here.
Representative Wallace.
Present.
Representative Testerman.
Here.
Representative True.
Present.
Representative Pratt.
Here.
Representative Marston.
Present.
The clerk is present. Representative Harriet Gathright.
Present.
Representative Pantelakis. Representative Pantelakis.
Representative
Laura
Pantelakis,
doesn't look like she can hear you.
are you present? Can you say yes?
She's waving.
Her picture is on the
Oh, we
on
can
there,
say,
but I don't think she can hear us.
Representative Pantelakis, if you are present, please say yes. All right, we'll come back there.
Come back, okay. Representative Massimilla.
Here.
Representative Bordenay.
Here, alone by myself.
Representative Muse.
I think Lawrence
Here and alone in my office.
device is on.
Representative Newman.
I'm here at home and my wife is in another room.
Representative Andrew Bolden.
I'm here in the committee room.
Representative Conley.
I'm here. My wife and kids are in the house, but not present in the room.
Representative Klein Knight.
I'm here and my family's in other rooms. I'm alone in this room.
Representative Bradley.
I'm here and alone.
Representative Abbas. Chairman.
The chair is present. Laura.
Representative Pantelakis.
Hello.
She was turning into
We got you, Laura.
Yeah.
Let me stop. I was.
She can, but I don't, Laura Representative Pantelakis, can you hear us speaking to you?
No.
We can hear her, but she can't hear us. We
Right.
have her audio. Her audio might be turned on.
As host, can't you just unmute her?
She is unmuted. And no, the host unable to unmute members. Is Representative Muse present? Representative Muse, just so you know, Representative Burt is not present today, so we don't have any members of the public participating anyway, but just for technical support, just give you a heads up. So,
She thinks we have her muted. I just asked her to try and unmute herself.
but she's not muted.
I know.
Awesome, turned down. Her microphone is off. She can't hear us.
Right.
So her volume on her computer might be down too low.
Well, while we're dealing with that technical difficulty, Representative Marston, you're recognized to lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Hopefully trying to do that over the sides.
Yeah. Should I say something?
Representative Gaffney, you're recognized.
We're asking for a moment of silence for Andrew O'Hearn, who lost his mother last week.
Now you're recognized for a 10-second moment of silence.
Answer. Thank you.
This is a pre-hearing announcement, and while we try to address Representative Pantelakis' technical issue, members using.
Hi.
Representative,
I'm fine now.
you can hear us?
Yeah.
Yes.
Representative Pantelakis, can you just confirm that you were here for the roll call record?
I'm here.
Thank you.
Knew it. So members using devices, who are participating remotely, and if you're in the room as well, your device must be muted or turned off to avoid a audio feedback. Now consider turning off your video if you intend to use the keyboard for taking notes. That will also prevent the clicking of the keyboard is what is being fed back into the devices. This is just what has been being reported. But for sound quality, it's important for members to speak clearly and be mindful of the location of the microphones. At the same time, be aware that most parts of the room, the microphones in the room will pick up every sound. Be careful about side conversations, because those will also be picked up in the background. I will also say that if you are shuffling papers or whatever, the microphone will pick that noise up. And members of the public have complained that they have a difficult time hearing this. The sign-in sheet will stop accepting new entries for those who wish to speak at 8 a.m. We don't have any members of the public testifying thing. The day of the committee hearing, if you sign in at that time, the committee will not have your name before then. However, the chair will provide an opportunity for you to speak after all registered names are called. At all times, raise your hand and be recognized. The sign-in sheet will close for purposes of registering your opinion at 11:59 p.m. the day of the hearing. At this time, we will now open the executive session on Senate Bill 92.
That's hard to see it.
Before we begin, my understanding is an amendment that will be offered. That will be amendment number 2021-1549H. The members in the room have a copy of that amendment. Do the members participating remotely also have a copy of that amendment?
Mr. Chair, the amendment number again, just to confirm.
2021-1549H.
Thank you.
Mr. Chairman, I don't know if they're having trouble on that Senate last meeting.
At this time, the chair recognizes Representative Rhodes to make the motion ought to pass as an offer an amendment.
Thank you, Mr. Chairman. Yes, I make a motion of ought to pass amendment 2021-1549H.
So you're making a motion of ought to pass, and then you're offering an amendment.
Yep, ought to pass, yep.
Is there a second to that? Second. That motion has been seconded by Representative Pratt, and now you wish to offer an amendment. And that's just for the record, 2021-1549H, correct?
That is correct, Mr. Chairman. Representative Green, did you second that motion?
Representative, it was seconded by Representative Pratt.
Oh, thank you. Mr. Chairman, I'd like to yield for you to talk about the amendment.
No problem. So with this amendment, first of all, just to clarify, the underlying Senate Bill 92 that was presented to the committee, in addition to having sections on bail, did have a section on involving background checks to a law enforcement officer who was being hired, and also had a section on vandalism or destruction of property. Those sections have been stricken in respect to candidates for to be hired as a police officer. This body, we passed Senate Bill, I believe it's House Bill 530, and that was also passed in the Senate. So there was no, under any circumstance, there was no need to pass the same section twice. So that, I will check the docket right now. I don't know the status of that, but I know it was voted on in the Senate, both the recommendation passed. So that should be on its way at some point to the corner off of the executive office for consideration. In respect to what this changes, and I will focus on section 3, number 3. A1, and you can see that there's a series of lists of offenses that are listed there. What is consistent with these offenses, and although they vary between murder, rape, sexual assault, different forms of battery, and child pornography, they all involve a crime against an individual person, as opposed to a crime against property or something, a white-collar crime. What it does, it changed it from being a 72 hours, being held for up to 72 hours, excluding weekends and holidays, to then have an arraignment or a bail commission hearing. What this does is it lowered that to 24 to 36 hours. The 36 hours would be ineffective, depending on when the arrest itself is made. And the problem with that is if someone's arrested around 8, 9 o'clock in the morning on a weekday, they may not make the court in time to be arraigned that day. So that's why you change it to 36 hours. For the members on the committee who served in the committee last term, we had a similar issue where a person, they may not be able, from a time perspective, if they're processing the person while they're in custody. These violent offenses and the crimes against individuals, it also includes felony use of a firearm under section RSA 650-A:1. It would be 24 hours excluding weekends and holidays. The courts are not open on the weekends, so if you are arrested on Saturday, there's not much that can be done in respect to that unless we have the courts open on the weekend, which I don't believe anyone's advocating. Under the current law, that is consistent with how the law is today. If you are arrested on the weekend and the court's not open, there are circumstances where you would be held to the next day the court is open. If you are charged with one of these violent offenses or crimes against the person, you would go directly, you would have an arraignment before the court as opposed to a hearing with the bail commission. And that person could be detained if the state is able to make a demonstration by clear and convincing evidence that by releasing the person, they pose a danger to themselves or to any member of the public, including the alleged victim. So by being charged with one of these, there's no presumptive burden on that the person being charged has to overcome. It's going to fall on the individual who's been charged. And if that's, it's going to fall on the state. The state would have to present evidence why they feel someone committed or charged with said offense remains in it. It can also, if a person is then held under that paragraph, meaning the state would have to meet their burden of proof that the person poses a danger to themselves and to the public. The individual does have a right to request a subsequent hearing that is under Roman numeral 4. Roman numeral 4 would allow the defendant to then call witnesses and have testimony. They can summons or subpoena any member or person they wish to testify, whether it's the arresting officer. They would be able to present any evidence that they wish, if they wish to try to overcome a challenge that hearing. There's also in the circuit court, there is a procedure that you could appeal it to the Superior Court, but in the short term, you would be able to have a full evidentiary hearing involving live testimony if that's the course a person wishes to take. The other section in it, what I did was this amendment rewrites what I thought would capture the original intent of the paragraphs. But if you look at Roman numeral 3, section B2, the original bill, there was some confusion on how that would operate, whether it's a rebuttal presumption, or what's the standard of the requirements of the evidence. There was some confusion. What this does, section Roman numeral 3 B2, has to do in cases where a person who's charged with an offense within the last 3 years has failed to appear at subsequent court hearings. So an example would be you have a suppression hearing, suppress, a search warrant, or express, some method of evidentiary hearing, and you have the police officer who's going to be present. You have the prosecutor, county attorney present. You can have the court present. Everyone's going to be present. But if the person charged with the offense does not appear, normally they would be considered to be in default. Well, if a person fails to appear at subsequent court hearings 3 times in a 3-year period, or 2 times on the present case, and the case that they failed to appear on is a felony, a Class A misdemeanor, or drunk driving, that under that case, if the state can show by preponderance of the evidence, a person has done that, that person would then be detained. Now, and the reason why is that there's a finding that the person is detained under that section. The presumption is that the person is not going to appear at the next court hearing. So they would have had to commit that or default 3 times in a 3-year period. So I don't believe that there's anything egregious about that. If a person continuously does not show up for court hearings to arrive at the conclusion that if we release the person, it's unlikely that they will appear at the next court hearing, well, there is a track record for that. But again, and that can be you can overcome that finding. An example I kind of came up with hypothetical, if a person's in the hospital but doesn't notify the court, well, that person would be defaulted because they didn't appear, but I highly doubt that a judge or the court would hold that default in a prejudicial manner towards the person, especially when their reason for not showing up would be well documented. What remains the same is this doesn't impose or change anything to do with the idea of cash bail. I understand that there's been a lot of discussion about cash bail and how that can have a discriminatory effect and have a hardship on certain people. They don't want people being held on $1,000 bail simply because a person cannot pay or post that bail. So that if a person is assessed a cash bail and they're unable to pay it, they're gonna have to demonstrate, the court would have to demonstrate by clear and convincing evidence that by requiring a cash bail, that will assure that the person will appear at the next hearing. So that's a higher burden of proof than preponderance of the evidence. Then under section Roman numeral 3C, this has to do if a person is released on bail already and they're charged with a felony, class A misdemeanor, or drunk driving, and they get arrested again, and they're for a felony, a class A misdemeanor, or drunk driving. And then, so now on bail twice, they're already been released twice, now get arrested a third time for a felony, a class A misdemeanor, or drunk driving, that there'll be a presumption fine. The state will have the, the state will have the burden of proof of probable cause, and that person will not abide by the conditions of their release. When a person is released on bail, it is, I want to say universally, always a condition that you don't commit any new offenses. In this case, this does not include class B misdemeanors. The reason for that is that if a person is charged with a class B misdemeanor, that person would not be facing any jail time, so it wouldn't make a lot of sense to hold a person in custody for committing a class B misdemeanor, or to revoke their conditions of their release, or revoke their bail because of that, when the underlying offense would actually include jail time. Again, these all can be rebutted under the hearing discussed in section 4. But again, the reason why that standard is probable cause as opposed to preponderance of the evidence, because this has to do with someone who's being arrested, and that's the standard to arrest them. So you want the burdens and the findings to be consistent burden of proof throughout the process since you're dealing with subsequent arrests. So there was a case I know last year where there was a person in New Hampshire in a 2-month time period was arrested 5 times for drunk driving in a 2-month time period. And the concern, and people ask, well, how can this happen? Well, because you're not convicted of any crime, there are open charges. The person's really being charged with 5 first offenses. And the reason why that can happen is because of the bail system. By the third, if that would have happened today, by the 3rd drunk driving charge, the court would then, they found probable cause, would have the opportunity to detain the person and not release the person. So I think getting to the point where someone has 5 of these, the person, I don't know the details of the case beyond what was reported in the media, but what I would say is that what this is trying to do is avoid situations like that. We had a case where, if you go back to the other paragraph involving the violent offenses, that's Roman numeral 3. That's Roman numeral 3A1. We had a situation where a person committed, they were arrested for domestic violence, and within 2 hours that person was released. They weren't brought before a judge. There was a bail commissioner. They were released and went back to that person and committed they sexually assaulted that person in front of their child. So we're trying to avoid situations where people commit violent crimes against people, and then they're released and they commit similar offenses. And those egregious situations have happened several times in a short time period. We had a situation where a person was robbed, the person is released, and the rob again within a 24-hour time period. So, and it's my thought that we're trying to avoid those egregious situations. It's the reason why the bail commissioners would not be making the determination of clear and convincing evidence. That's an evidentiary standard. That's a burden of proof, and it's belief. My thought is that should be something that is decided by a judge, decided by the court. And I'm talking about the crimes that are violent. Really, when it comes to domestic violence, that's what I'm referring to: murder, rape, child pornography. These are the crimes that I think we can make a suggestion that pose a threat to public safety. And I think in domestic violence, it's statistically shown that that's a crime that elevates and is often repeated and underreported. So when you have a situation where it elevates each time, again, this is really taking into consideration the violent nature of the offense, but also protecting victims of these crimes to make sure that they're not going to be repeatedly a victim of the same perpetrator. So I can answer any questions about this and open it up for discussion. Representative Bradley, you recognized?
Thank you, Chairman Abbas. So just to be clear, this amendment focuses strictly on violent crimes.
So, well, in respect to Roman numeral 3A1, yes. And that has to do with the difference between that section and the other two sections I discussed. The other two sections discuss either violating the conditions of your release. So those are not necessarily, if you don't show up at court here, you're not committing a crime per se, but you're violating the condition of your release. These, I say the term violent crimes. Some people make the argument that, well, statutory rape is not violent, or child pornography is not violent. Maybe violence, I'm looking at that as that's still a serious crime against a person. So is it violent in nature? Perhaps not. But I would say the overwhelming purpose, all these are robbery. I think that's violent. Trafficking of a person. I'm going to consider that to be a serious offense against a person. You know, is it violent? I think that it entails a threat that goes along with kidnapping, aggravated felony sexual assault, second degree assault under RSA 631. To domestic violence, first degree assault, homicide, stalking. Again, stalking usually is a premeditated offense that involves against a crime against the person, and that's also often a crime that can escalate. And again, child pornography. Child pornography is a crime where simply having the material, funding the market for it. The courts have consistently found that funding the market is in and of itself supporting the industry, and you're supporting it. That's supporting a crime against a child. And these type of crimes, you can prosecute, you can convict the person, they can serve jail time. For someone who's worked on cases involving violent crimes against individuals, I've represented the defendants and I've represented victims. So I've had a very hands-on approach with dealing with this, and I don't know if victims truly ever recover from some of this. And the person can serve jail time, they pay their debt, but I think for the victim, it's a tough situation. I'm not sure they ever get past it. Representative Bordnick?
Thank you, Mr. Chair. You mentioned domestic violence and protective orders, but aren't those two crimes, aren't they already taken care of in the present law?
Yes, the law addresses when you're arrested for domestic violence or violating a restraining order, those are already a crime, and when you're arrested for a crime, there are circumstances where you can be held. But one of the examples that I gave was a person who was arrested for domestic violence and released within 2 hours, and went back to the alleged victim's house, and then sexually assaulted that person in front of that person's child. So I would say, is it addressed by the law? Yes, but is it doing justice? I think it's not in the interest of the public to have a system where people are being released on these crimes, domestic violence type crimes, where they're able to repeat it. And that's why if the state can prove this by clear and convincing evidence that they feel that person poses any type of threat to, whether it's to the public or to the alleged victim themselves. Again, just because you're arrested for violating a restraining order or you're arrested for domestic violence does not mean you're going to be held. The state has to demonstrate why they feel that you are a threat to the public. Now, in order to do that, we can talk hypotheticals, but there needs to be some basis. Maybe the person has several other violent convictions on their record. Maybe the evidence that's been presented during the hearing is overwhelming, whether there's text messages or bruising or it's on video. I mean, we've seen that where things are captured on video, so they have situations like that. If the person's violating a restraining order, understand there's already have a victim of abuse, and now there's an order that's intended to protect that person, and that person's not following the order. Now, just because someone violates the order doesn't mean that they're per se a danger to the public, but I would say that they're certainly not following the order. They're unlikely following the conditions of their release if there is an underlying criminal case. So I don't think the law sufficiently addresses and provides enough protection for the victim. It's my.
However, present law does make an exception for releasing without bond for crimes of domestic violence and validating a protection order. That is in present law. The addition of other violent crimes, we have to consider that those are accused. They are not found guilty of having committed those crimes. Anybody can be charged with a crime that without evidence. So while I agree that your amendment does narrow the scope of SB 92, I do not think it is ready for becoming law. Thank you.
In respect to that, anyone who's arrested, who's out on bail, or is going to a bail hearing hasn't been convicted. So under that logic, you wouldn't have any bail system whatsoever. So I think it's important to understand that you're right, we're not dealing with someone who's been convicted, but the highest burden of proof is beyond a reasonable doubt. That's what you need to get the conviction. The next step down is clear and convincing evidence. If the person is simply charged with one of these violent offenses, and if the district attorney or the county attorney does not have their ducks in a row to present why they believe that person's a continued danger, simply saying, well, they were accused of this, I don't think that comes anywhere close to meeting the burden of proof. You would have to provide some type of, if there is physical evidence or it's photographs, often whether it's text messages in writing and making threats, there would need to be more to meet that burden, satisfy it in order to actually hold the person. And if the state is able to do that, the defendant still has the option to then get a second hearing under paragraph 4, where they can then summon witnesses to actually appear and testify and demonstrate again why they're not in front of the policy. But if the state can't meet that burden, you can be charged with any one of these. If they are unable to prove that, then the person's should not be held. I mean, that's a pretty high burden of proof to meet. Really, when you're early on, but at this point, when you're investigating a crime, it's either something that just happened or the person's been indicted. If the person's been indicted, you're going to have a long list of evidence to get gotten to the point where you can make that argument. If the crime just happened, again, they're going to have to be relying on evidence why they're arresting that person. If they have a surveillance video, you're going to have something that actually demonstrate why you remain a threat to the public. So that's up to the state to meet that burden. Representative Testament.
Thank you. Thank you for the question. Do we have any statistics on how many people are arrested and what percentage of those eventually go through the court system and for plea bargains are convicted? I'm just curious, is it 90%, 80%? Is there any statistics on that?
Are you asking, so from when people are charged with any type of offense and whether they're actually convicted? I don't have those statistics. When you get speaking generally, when you have minor offenses, meaning like class B misdemeanors, or you have a class A misdemeanor, usually involving, when it's not a crime against a person. If a person, there are different type of plea deals that are.
This kind.
Oh, these violent offenses? Okay, so my understanding, I don't have the conviction rate, but my understanding that the belief is there's about 4,000 to 5,000 of these types of charges per year. Now, it's hard to, because sometimes you can be charged with second-degree assault, but also first-degree assault. So there is a little bit of overlap. So one incident may involve both. The reason why they charge both is they may not get first-degree assault as a conviction, but so my understanding is that the consensus is there will be about 4,000 of these types of arrests involving an individual, but the offenses is higher than that for that reason. So, like child pornography, you may have several images or pieces of videos or whatever of child pornography. Each one in of itself would involve a potential charge.
What I'm trying to get at is how many people who are charged with these kinds of offenses eventually are penalized by our judicial system? Does that give me an idea of how much let's say, concerned that that's really what it is, that this is going to get misapplied? Only 98% of the people who are involved with this eventually face some sort of penalty. There's only 2% that they're worried about. I don't worry about all of them, but I just.
So I don't have the conviction rates, and then again, just because the person's not convicted, again, if you plead down to something else, the numbers can be deceiving, but I don't have the exact statistics. Representative Muse.
Thank you, Mr. Chair. I just had a question about process. The specific changes in this amendment, were any of those actually vetted by the Bail Commission before this amendment was prepared?
So are you asking, did I vet this bill for the Bail Commission? Is the amendment, did I vet it before them, that commission?
That's correct, either the bill or your amendment.
I did not vet the amendment before the commission, and I will tell you that I don't believe the underlying Senate bill was either. In respect to the commission, and I believe Vice Chairman Welch is a member of that, this was something that was before the Senate. There was a public hearing on it, and then there was a public hearing before our committee as well. What I would say for me, in my opinion, is the original Senate bill 92, well, I should say original, but the bill that was presented to our committee, we provided for holding an individual for up to 72 hours, excluding weekends and holidays, if they were charged with one of these offenses before they were brought to court. I dialed that down to 24 to 36 hours, and I explained that why. So I reduced that time period where a person would be held, and you still have to take into consideration the weekends and holidays. So that's what this did. What this also did is I added I put the burden of proof back on the state to if they're gonna, in order for the person to be held, it would be by clear and convincing evidence. And my understanding of case law in New Hampshire, if a person is going to be held and it's involving a life sentence, and if you're going to deny that person bail, the burden of proof would be clear and convincing evidence if you're going to detain the person without bail. That's the existing law in New Hampshire. But I am doing some of these offenses, as egregious and as they are and violent as they are towards a person. I'm putting that same standard, even though it's not a life sentence. So it's a higher standard, in my opinion, what would ordinarily apply to a person being held, let's say, on domestic violence. Just a misdemeanor domestic violence charge. I'm putting that clear and convincing evidence standard that would apply to someone facing a life sentence. So in my opinion, it's actually upping or increasing the burden in order to obtain someone. But no, it was not vetted before.
Mr. Chair, I appreciate the time and the effort that it took to go through the bill and to make these changes and to make these recommendations. And I think that based on the problem that's before us, it's very possible that the members of the Bail Commission could have come up with exactly the same thing. It's also possible that they could have come up with something very different. And part of the problem that I have with the process used to create this bill is we will never know that because we've short-circuited the role of the Bail Commission in this process. So my point isn't necessarily that the changes, the way that they're framed in this bill are bad. I think the problem is we had a narrow set of stakeholders that actually crafted this bill. And to my knowledge, we had two legislators following the Senate hearings who sort of went over the bill again and crafted this amendment. What we really don't have is full representation of all of the different stakeholders on the Bail Commission. I think we have a lot of representation from the members of our police departments. And I think they're important stakeholders and they should have a lot of representation. But I think that this is a state where ultimately legislators need to write bills based on the input, especially a bill like this that's so complex and with so many moving parts. We need to write bills advised by all of the stakeholders, not just one narrow set of stakeholders. So that's my issue with this bill, and that's my issue with this amendment.
Well, I can assure you of this, that no stakeholder wrote this amendment. I will assure you of that. This was something that was worked on by myself with the input of another representative who's not a member of the committee, but who has a legal background of their own. So this is not something that necessarily this was not written by any organizations. So the way this was written, I don't care who writes it. If I put my name on it, I would stand by it. So it wasn't, but it's not something that would, I would say was written by an organization or a state.
I understand that. Thank you, Mr. Chair.
Representative Andrew.
Thank you, Mr. Chairman. I appreciate the chairman's long explanation of this amendment, and it confirms my assessment of the amendment, and that it contains many substantial changes from the original bill. As far as I can tell, the language in 1549 hasn't been reviewed in a public hearing or work session. Make no mistake, this amendment will roll back bail reform in a large way in New Hampshire, and in doing so, it bypasses the established process of the Bail Commission entirely. This language did not come out of the Bail Commission. It does not reflect any of the recommendations of the Commission as far as I can tell. And in fact, the language contradicts a critical finding from the Commission's latest report, which specifically states that failures to appear have actually gone down during the pandemic, in part due to the expansion of telephonic check-ins. Additionally, the language in this amendment would impose significant changes to a statute that was modified just this past summer. Since the enactment of those reforms, we've been in the midst of a pandemic, resulting in numerous unprecedented conditions and circumstances. To me, it seems like we've not given the most recent statutory changes a chance to soak in. We've not given the Bail Commission a chance to review the effects of those changes. And instead of waiting and listening to the suggestions of the Bail Commission, this amendment seeks to place the cart before the horse and push through some substantially complex changes. How can we expect the Bail Commission to do their work if we keep moving the target? For this reason alone, we should reject this amendment, but it's not the only compelling reason. The second reason to oppose this amendment is a financial one. As you know, county delegations are setting their budgets currently. I happen to be on the House of Corrections Budget Subcommittee in Hillsborough County, and they've reduced their budget significantly due to a large reduction in jail population due to bail reform. If this amendment passes and bail reform is rolled back, this will cause a huge budget shortfall at the county level. Now, I don't want to be responsible for breaking the bank at the county level. And finally, another compelling reason to reject this amendment is legislative liability. Now, what do I mean by that? This amendment attempts to convert an omnibus bill into a single issue bill, which I certainly can respect. However, we must not lose sight of the fact that amending this bill will result in a committee of conference. And I'm sure that most of you are aware that the committee of conference can generally do whatever it wants to with the bill. And no doubt the members of the other body will be pushing hard to reinstate the pieces of the bill which we're proposing to remove here today. Who's going to be selected to be put on that committee of conference? No one knows. At that point, the members of this committee will not have any real influence over what happens to the bill. So I'm going to vote against this 11th hour amendment. I would suggest that if the amendment were to fail, that we seriously consider retaining the bill so the committee can use it as a possible vehicle for future changes recommended by the Bail Commission. Thank you, Mr. Chairman.
Thank you. And just to clarify, there's been less court hearings altogether. There was a good portion of the time during the pandemic where the courts weren't open at all unless it was an emergency hearing. So yes, the video hearings have somewhat resulted in less defaults, but when the courts were closed in general, unless it was an emergency hearing, you're going to have less defaults. It's just a matter of having less hearings in the process. In regards to rolling back bail reform, respectfully, this doesn't roll back the entire bail reform operation. This is only applying to violent crimes against the person. It's again, felonies, sexual assault, child pornography, crimes against children, rape, and murder. This is not rolling it back on people who are charged with, simply because you're charged with drunk driving and class and stuff. So it's not rolling it back. In regards to what happens at the committee conference, I hope to be, if this were to pass and it's not concurred by the Senate, I can't speak to the motives of what would happen in there. But I know that like I said, I put my name on an amendment, I put some time into it, and there was a lot of suggestions about perhaps removing some of the violent offenses from this list to make it more, to lower the impact on the court and to lower the impact on the county for the expenses. And the people I've talked to, whether it's the law enforcement or at the county levels, they were supportive of this because of the public safety aspect, even though it could have a potential financial impact. But I look at these lists of offenses and from a moral perspective, I wasn't willing to remove any of these offenses. And if I am selected to be on the committee of conference, that's not my decision. I wouldn't compromise on removing any of these offenses. That's just my position. I wouldn't, if I was going to just kind of pass it through, my goal is not to just pass them and pass it. I would stand by this. The underlying bill, I thought the 72 hours was a little too much. So, and I still think it is. Representative Tessler? Actually, I corrected myself. I have to, let me, Representative Tessler, I will come back to it. Let me recognize the members who haven't had a chance to speak yet. Representative Newman, you are recognized.
All right. Thank you, Mr. Chair. I have a question just for you. Could you tell me who the representative was that was speaking just before? We can't tell who's in the room, and I didn't understand that.
That was Representative Andrew Bolton.
Andrew Bolton. Okay. Thank you very much.
I
agree with everything you said. Excuse me?
We're referring to my first and last name, just it's just substituting for someone with a similar name. We have two Greens today as well. This one's wondering.
Okay. Thank you. I agree with what he says, especially the financial part. I was on the jail, the way the jail works now, in Hillsborough County, they're down by 100 prisoners due to bail reform. I think this is a massive change to the bail commission process the way it works now. In previous meetings that we've had, I asked that what the words that it should be considered by the court and the bail commission, what that meant. And I never did get a satisfactory explanation, but now as I see in your amendment, it doesn't say the court and the bail commissioner, it says the court and if applicable, the bail commissioner. And then later on, it goes on to say that in these cases, as I understand it, it says that in any of these cases, that the bail commissioners shall not be assigned these cases. So that leads me to believe that this is an attempt to change all of the things that the bail commission recommended. It's an attempt to change the legislation that was passed 7 months ago without any data. And I appreciate all of the anecdotal cases that you gave to us. And usually those anecdotal cases are the most egregious types of crimes. And so that is kind of, I believe, is intended to make us believe that this bill should pass as you would like to see it amended. I don't agree with that. And and I've talked to a bail commissioner. An example of things that could happen, even if you change the hours to 36, people, if I'm correct, people that are accused of these crimes now go before bail commissioners, and bail commissioners make those decisions. I think you said something when you were describing to us all of the changes that were made. You didn't believe that the bail commissioners could make a correct judgment about the various types of necessary proof that you have in this. And so you get to some anecdotal cases that I heard from a bail commissioner, for instance, where there was a domestic violence case with a man who had Alzheimer's and came before the bail commissioner. And it looks to me that if this amendment passes, that man would have remained in custody, but he did not remain in custody. He was released to a family member with conditions that he could not have. He had to stay away from the other person. And then there was another example that he gave of something about child pornography for someone that, for whatever reason, had it on their computer, maybe even unbeknownst to them, that it was downloaded because they visited a site somewhere. And all of those people would be retained in custody because of that. And they wouldn't see a bail commissioner. And if they don't see a bail commissioner and they're arrested at Friday night at 8 o'clock, they won't get to see a bail commissioner. They'll have to go to court. And my thinking would be that the court would not happen until the following Monday, and if it's a holiday, the following Tuesday. For those reasons, I am not going to support this amendment. Thank you, Mr. Chair.
Representative Newman, just to clarify the procedure, if a person does appear before a bail commissioner and they are released, or they post bail or not to the bail commissioner, the common practice is that the defendant would waive their arraignment, so there wouldn't be a court here for an arraignment. And the reason why is that the arraignment would be, you would only do that to challenge because you disagree with the bail commission, what their determination is. If you are, I suppose, there's nothing, no precedence for someone challenging a finding of a bail commission when they paid and posted the bail that the bail commissioner assessed. This is, when I say that a bail commissioner shouldn't be making said finding, if the finding is to detain an individual who's been charged with one of these violent offenses against another person, that's a high burden of proof. It's clear and convincing evidence. And that is a high evidentiary standard that it is my belief that it's more appropriate that the court make that determination, because that's an evidentiary determination that is often, it should be determined by the court. And we can go through several hypotheticals, but ultimately the state would have to meet that burden So whether a person commits this offense or not, there's no presumption that they be held because of the charge itself. In regards to child pornography, and that's, to be honest, I'm surprised that that's one of the offenses listed that's come up the most. So, in my understanding with ICAC, Unit Crimes Against Children Division, when they're able to tell, we really follow the data in a way that's difficult to explain. That they know how long you've been on a website. They can tell if you've been whether you meant to go to that website. I guess you can be redirected to a website and you're not sure. They can just tell how long you've been there. And they also can tell whether you were on a website and actually watched or downloaded any data off the website, which would mean you would have watched some type of video. So in that case, you're dealing with, if ICAC were to make an arrest, and I understand it's common that no-knock warrants are often used in these type of arrests. One, about the fear of the destruction of evidence, but two, the fear out of the officer's safety. This year, we had an incident in Florida, so it's out of state, but they knocked on the door and 2 federal agents were shot right through the door, and they were serving a warrant on the child pornography case. There's a lot of belief that a lot of people charged with this offense tries to commit suicide by copying. So in that type of case, they're going to have, I would say, the state, if they wish for the person to be detained, would need to present that evidence in the court and why they feel that person continue to pose a threat to public safety. So again, that burden's on the state, but that shouldn't involve someone who's incidentally on a website for a short period of time. I mean, the state's gonna have to prove that case, at least in regards to the burden to have the person detained, if that's what the state's asking for. Representative Newman? You have to unmute yourself.
Maybe I don't understand the wording in the amendment that deals with bail commissioners. And it says that these people shall not be brought before a bail commissioner and shall be held in custody pending arraignment before the court, which shall without unreasonable delay and within 24 hours of the time of arrest, excluding Sundays and holidays, etc. So does that not mean that anybody that is charged with these crimes, no matter what the circumstances are, will not be able to try and refute the decision not to release them? Just explain that particular change to me.
So I understood during our conversation, there was some concern that bail commissioners would be eliminated altogether. Bail commissioners would still exist. If you're charged with any of these violent offenses, in that scenario, you would not be brought before a bail commissioner. You would be held to be brought before the court. So depending on when you are arrested will depend on when you were brought before the court. So that's how that would work. And then there is no presumption that you are held. So what would then happen, you would have your bail hearing at the court, which is that during the time of your arraignment, and then what you can do is challenge that. If they make a finding by clear and convincing evidence, you can then request a subsequent hearing on paragraph 4 to summons witnesses and basically get another chance to demonstrate why you're not afraid of public safety. Does that answer the question?
I mean, I'm looking at the exact words and it says they shall be held in custody. And to me, my fear is that anyone that is arrested and charged with one of these crimes shall be held in custody. They won't see a bail commissioner who could make a decision to have them released in the current system, and they will remain in custody. And if it happens, depending on the timing, they could be held in custody for much longer than 36 hours. So unless we're going to have court hearings, I don't know how they would get released. Maybe you can explain it to me.
So if you get arrested for one of these offenses, you can be held for up to 24 hours, but no more than 36 hours. We has to exclude the weekends and holidays if you have to be brought before the court. When you're brought before the court, that would be the arraignment. If the state does not ask you to be detained, which again I'm not sure they will on every single one, but that's up to the state to ask. If that is the case and the state meets the burden of proof, then you'd be detained. If you don't, it says towards the end of the paragraph, if the court does not find by convincing evidence that a person must be detained, the court shall order the person released pursuant to paragraph 1A or paragraph 1B, or if applicable, temporarily detained pursuant to paragraph 1D.
So is everybody detained or not? Excuse me, can I have a follow-up?
Yes.
Yes.
Not everybody.
That is my follow-up.
So when you are arrested, you have been placed under arrest. When I use the term detained, that would be when your bail is, when you have your bail hearing for the court, you're going to remain in custody until you're brought to the court in 24 to 36 hours. And you could be detained if the state meets that burden. Representative Newman?
Yes, thank you for the follow-up, especially since it's probably the third one. So you said when brought before the court, if they're arrested on a Friday night, when are they going to be brought before the court? Because now that the bail commissioner is not involved, there is not a person who can make a determination whether he can be released or the person can be released, meaning all of them. And it's subject to a burden of proof that happens before a court. But I think our understanding is that the person in that circumstance would not get to a court until the following Monday or Tuesday. I'm just confused on how this thing is going to work.
Well, if a person is arrested on Friday night for felonious sexual assault, trafficking of a person, robbery, possession, manufacture, and distribution of child sexual abuse images. You're arrested on a Friday night, and you would have to be brought before the court within 24 hours of them being open. Now, it excludes weekends and holidays, and that's just the byproduct of the court not being open. And that's currently not every situation a person is necessarily brought before the commission. It's not always done that way. So that's something that's sometimes at the option. So they're going to be held for that time period, waiting for their arraignment. That's how this will work. If they don't bring the person within the 24 hours and the weekend and holiday exclusion doesn't apply, or the 36-hour provision doesn't apply, they're holding that person, I would say, illegal. They need to be brought within a reasonable time period. Even 24 hours, the person should not be up against the clock. They should be processed and brought to the court as soon as possible within a reasonable time period. And I believe if it's not done in a reasonable
very much.
And just to clarify, even if you're brought within a 24-hour time period, 24 hours to the court, it doesn't necessarily mean that was in a reasonable time period. If you're just sitting around waiting out the clock, I would find that to be highly inappropriate.
Thank you for that clarification. But right now, they see bail commissioners, and for these laws, they won't see those bail commissioners now. And I think that is egregious. Thank you.
Representative Klein-Knight.
Thank you, Chair. I think it's inappropriate for us to kind of skip the line and not take the advice of a whole commission that just passed a law that we haven't even been able to see the effects of because the courts have been shut down because of COVID. So we haven't even been able to see how this new law that all the stakeholders met to effectively come up with in a bipartisan and collaborative way. I just don't think the democratic the democratic process is getting a fair shake, if we're bypassing a whole group of people from all over that have the most important voices to an experience to raise in this issue, and we're basically, you know, ignoring their advice by not even seeing how what they came up with first is going to affect our state. And I don't think anybody's going to argue that these are really heinous crimes and we take them very seriously, but due process and, you know, fair democratic, you know, instances for people getting their time to, you know, prove to everyone that they are innocent, and heaven forbid, like, you know, we round people up that are innocent and then they aren't treated fairly and we have to wait days. I think we open the state up to litigation by not fairly incarcerating people. You know, we just got sued because we were doing that in the ER, you know, and we even have inmates right now waiting for psychiatric care. We can't even house the public effectively for that kind of situation. I don't see us throwing more resources at our inmate population. So this is a really big issue that I don't think we've had enough time to get everybody's opinions on that will be affected by this if it were to pass. And I think it would be really irresponsible of us to pass this without hearing all those voices from the people that have the most experience in our state on this issue. Thank you.
Thank you, Representative Knight. I will just point out there was public hearings for the Senate and a public hearing for this committee. So any stakeholder, any member of any commission, anyone had multiple opportunities to offer their input on this, on Senate Bill 92. There was plenty of opportunity to do that. So no one's been excluded from any process. I think looking at what we have before us here, where this is not something that is being done to go around anyone's recommendation. There are commissions that exist that put together recommendations. Those recommendations are up for this committee to evaluate. And it's up to the legislator is the one that actually is the body that actually decides which part of those recommendations should or should not be adopted. So I don't think that we are necessarily bound by another, whether it's an interest group or another commission's recommendation. It's certainly helpful, but no one's been excluded from the process. Any insight on this? I'm looking at it as I would ask, this is a question you can answer, which part of section 3A1 do you feel that is inappropriately included? What part of that process is inappropriate? Because under the existing law, if you're charged with homicide, for example, or any offense with a life sentence, the standard is clear and convincing evidence whether you're going to be detained or not. So that's already a practice being followed in the state, and we are adding, well, other less serious offenses than homicide. We're adding other offenses to that standard, to that category where you could be detained by meeting that, if the state meets that high burden of proof. So right now it's a lower standard. So I guess the question is, do we want a lower standard or the highest?
I think we need to get more of the stakeholders in the room and see what their thoughts are, not just the chief of police. And I think that we need to hear from the bail commissioners. You know, I just don't think this is giving a fair shake to all parties involved. And what really troubles me is an overnight stay or a whole holiday stay just because we don't have the judges or the time to book people properly. And that right there leaves us open for involuntary incarceration that, you know, that we just got sued for. Like I'm saying, I just think that we didn't have enough time to study the potential effects of how this is going to be, after it's implemented, how it's going to affect everyone.
So and this is for the committee to put in consideration. Last week, the case Representative Knight's correct, the case came out of the Supreme Court in New Hampshire. If you were involuntarily detained, you had a right to a hearing within 72 hours. Well, the issue was that there wasn't enough room in the facility for people who were being involuntarily detained. And the question was, when does the 72-hour clock begin? And some people took the position that it doesn't begin until you have your place in the facility. So people who were sitting in the emergency room, let's say, for 2 weeks, waiting for availability. They were being held during that time. And the New Hampshire Supreme Court ruled that to be unconstitutional. I agree with that decision. And I don't think that just because there's not enough resources, that person should be held. Representative Klein Knight, a person's being held over a weekend or holiday because the court itself is not open. And that's currently a problem that I don't know of many courts that are open. They don't open on the weekend. So that's not something that we're changing. So that's that. I will say in regards to resource issues, when HB 2 passed in the House, we did create 2 additional positions for circuit court judges. My understanding, the Senate is, of course, the budget hasn't passed, but they've created 2 more additional. So there'll be 4 additional circuit court judges to address this. And so I think that the resource argument issue has been at least somewhat addressed by what is being done. But that we have no control over whether the 2 additional ones pass on. That's for finance committee to. I support the adding of those judges, but I can't control whether they remain or those get taken out. That's not. This is where we're dealing with.
I'm not saying. Sorry, can I just add a comment? I don't think this may be a bad idea. I'd like to retain it, or I'd like to have more time on it, is what I'm saying. So we can really study all the details of how it's going to affect the whole process, the bail commissioners, the police, the person incarcerated. I just don't think there's so many moving parts to this that I just don't think we have spent enough time on it to make it the best it can be.
Representative Pantelakis, you're recognized.
Thank you, Mr. Chairman. I respect the Bail Commission very much, but they were appointed by the government. We are the legislators that are sent up here to respect the people and protect them. And so many things have gone on in the past 7 months that we are laughed at because we made a bill like that. And I want you to know that the bill has been in place before for many years, and it seemed to work all right. None of us want to put anybody in jail because they did a minor thing, and it doesn't happen that way. My apologies to my fellow Democrats, but I will vote for this amendment. Thank you.
Representative Rose, you're recognized.
Thank you, Mr. Chairman. There's a lot to say here, and the first thing I would like to say is, with respect to what Representative Pantelakis just said, is one of the things I have written on my notes. We aren't talking about keeping somebody in jail that ran a stop sign. We're not talking about keeping somebody in jail that was arrested for smoking marijuana. We are talking about keeping somebody in jail that has done horrendous, or is accused of doing a horrendous thing. And it's very easy to stand back and say, well, the person needs to be heard. But what about the victim? Why are we are protecting the wrong people here? And when it's your family member or it's your child that is the victim, that is this child pornography, it's their image that's on the computer, you're going to think differently about that person being released that did that. And it's very easy to stand there and say that you're protecting these people, but you're not. You're not protecting these people. You're riding this justice horse and you're getting nowhere. What if it's your child that was held down, that was raped to death? Oh, we'll let the guy out. It's been 3 days. We need to protect him. No, we don't. You need to think of the victims. It's not as simple. We're not talking about a mistake, right? We're not talking about calling a tomato a vegetable when it's a fruit. We're talking about terrible, terrible crimes. This isn't silly. We're not talking about small things here. And I think everybody that's sitting here protecting the people because they may have to sit in jail for 3 days. Well, lucky them, it's only 3 days because the victim is being affected for the rest of their life. And so is their family. These are huge consequences. The people, when they're convicting these crimes, they're not thinking about because they're only thinking about themselves. They deserve to be in jail. That's all I have to say.
Thank you, Representative. Just to clarify it too, for the person, when the person's held or detained, again, the state, if that's what they're requesting, has to present enough evidence to demonstrate by clear and convincing evidence that person is a threat to the public or themselves. So again, the court will be needing to make a determination that this individual who's been charged with a violent offense against someone continues to be a threat to public safety. And that's the point I'm trying to get across. You need to, it's not just that you committed the crime itself. It's whether you actually remain a threat to public safety is the issue of whether you'll be released or not. So whether that's done by a judge or a bail commissioner, I think having a judge evaluate that burden of proof by having a higher standard really lets you identify the individuals who actually can have a more accurate finding. It's a higher burden done by a judge. I think, I'm not saying bail commissioners don't know what they're doing, but I would put the credibility of the judge ahead of that. That's just my. Representative Conley?
Thank you, Mr. Chairman. I'll start by thanking you for the good faith effort I think you put into addressing concerns that were in the initial bill. I'll also echo comments made by several members that, we don't really have all the information. The premise behind the initial bill that we're considering the amendment on was that the effort from a few years ago had flaws. And so now we have an effort to quote unquote fix it that hasn't been thoroughly vetted. So I'm inclined to support this effort. I would also be inclined to support it in a year when we have more time to look at the effects. So that's all I'll say, but so I remain torn on this, but I think we can get a bill we all can support if we hold on to this for a few months, work on it in the fall, bring it back early next year and get it to the floor. Thank you.
And Representative Conley, if I may ask, and I respect the dialogue that we're having today. I understand this is, I think we're all voicing concerns, and I appreciate that. When it comes to making changes or potential changes to what the amendment that's being presented is, I guess my question is, what will we change about? I look at it as we have a limited scope of the offenses where this would apply to. That's the crux of what this is. And is it the preference that that is decided by a bail commissioner as opposed to a judge? I guess my question is, if there's suggestions to be made, I'm more than willing to listen. And I consulted with a lot of different members and a lot of different people when putting this together, and took into consideration a lot of different. That's why, if you notice, there's a couple amendments floating around, and every time I did, so when I say that I respected a lot of different opinions on this, is one opinion satisfied in its entirety? No, but there was some of a balancing act to kind of juggle some of the things together to make it address a lot of concerns. I guess I'm asking you is, what concerns do you have that you would prefer changed? Would you want to eliminate some of these offenses? Would you rather bail commissioners decide bail when someone's charged with aggravated felony sexual assault as opposed to a judge?
So I go back to the fact that I am not an expert on these things, and I listen to people who know more than I do and consider the arguments they make. And there seem to be truly compelling arguments on both sides. So I think your amendment goes a long way to addressing the concerns I had. At the same time, I look back at some other bills we've retained. These were things that, in my mind, were great, didn't need more work, but I think that retaining them ended up being the correct decision, because I think it's going to get us to a final product that we can all, or hopefully a large majority of our committee can support. And I see this as part of the same, in that same vein. If there are problems with bail, we absolutely should fix it. I think we're on the right track. Rather than identifying individual issues, I think it's more about getting members to be more comfortable with the potential effects of this amendment that we haven't had testimony on at all. So that's where my argument comes from for retaining. Nothing suggesting there's a problem with this, more about just slow down this process and do it right so that we don't have more bail reform coming back before this body and this committee in the next few years.
Thank you, Representative Conley. So I know we retained, I don't recall the exact amount that we retained, but when we retained some of the bills, those are House bills, and we had a specific deadline to meet, and we had 59 bills. I think our committee had the most. So some of those bills we were not, and I wasn't ashamed to admit it, we were only going to meet on a limited basis as well, based on what was available. So we retained some bills. More out of abundance that we didn't have we couldn't ensure that we could actually put the time in. For this bill, this has been assigned to our committee for over a month. And I said last meeting, the meeting before, the rules only allow us to put forward one amendment. We can't have multiple amendments to a bill. And if there's any amendment or any change that anyone wants, to work with anyone else putting forward an amendment so they can take it into consideration and put all things together. I respectfully, I haven't had many people, respectively, your caucus come to me and asking me to make any specific changes to the prior amendment that was circulated around, or the one that was, I think this is now the third version of my draft that's kind of floated. So I haven't been, no suggestions been made to me in a month. So I'm still all ears, but a lot of people want to say, we want to study more, but we've had the bill for quite some time. So I'm just wondering if we retain it, I'm just curious on the time frame that if we're actually going to be looking into this. So I haven't been presented any ideas. So
Chairman, can I respond, and then I'll mute myself and won't talk again. So my concern is, again, as a layperson, making changes on this broad scale that affect a vast number of people who are arrested, will be detained, will have costs involved, stresses on the court system. These are legitimate things that we just don't have information on. And, there are bad faith efforts in this House to delay and hopefully kill. My suggestion is not one of those efforts. Let's get something that we can all support, or that majority of us can support, and address the concerns so that we're not having these, we don't have all the information. So that's the point that I'm raising. Not that it's a bad amendment, doesn't seem to be, but there's just things that a lot of us have raised that we don't have answers and can't get answers at this moment. So that's all. I'll stop, but thank you.
Thank you, Representative Collins. Representative Green.
Thank you.
Representative Dennis Green.
Thank you. My thing is that I think you put a lot of work into it, and we've had time to work on this, and no one has come forth other than the time that you put into it. And I think if we pass it, then if there's some discrepancy, that somebody could put in a bill next fall and change maybe one or two parts of it, but I think it's time to pass it and put away some of these criminals that are very serious crimes.
Thank you, Representative Green.
You're welcome.
You want? So you have your hand up?
Yeah, a long time ago.
I thought you put it down. Sorry. I thought you put it down.
Yeah.
Representative Galbraith.
Thank you. Dr. Speak.
Yeah, I didn't realize you had.
Yeah, you said you're gonna come back to me a long time ago. You never did.
That's right.
Yeah.
Get involved.
So I just let you run with it. First of all,
My apologies.
I just want to address something that I just heard that no one's ever said anything to or had conversations with you, and I've had conversations with you in regards to this particular bill. And the reason why I had the conversation is because Bradley Greenland sent us that commission on pretrial detention, pretrial scheduling, and the services. And I took the opportunity to read through it. I hope that the rest of my colleagues read through it because that was an important commission. And I just want to say, let me give you an idea who was on that commission, even though two people wrote the amendment that you have. So, and I also want to speak to another colleague who talked about the passion of the victim. I don't think anybody in this room is more passionate about a victim than myself, but I am about due process of law. So we had two senators, as a matter of fact, that chaired that commission, all right? Both sides of the aisle. We had Representative Rod, that's no longer with us, but she was on that commission. Representative Woodbury, Representative Welch, the Honorable David King, New Hampshire Circuit Court, the Honorable Tina Nader, New Hampshire Superior Court, Attorney Thomas Verlappe, Associate of County Attorneys, Attorney Sean Locke, Office of the Attorney General, Superintendent Stephen Church, Rockingham County Corrections, Attorney Randy Hawks, New Hampshire Public Defender. Those are people that were on that committee. And believe me, they have a lot more education than most of us in this room today. And to take that a little further, Chief of Police, Department of Corrections, everyone had the opportunity to come and testify before this committee. And the community, the people, our constituents came and spoke before this committee. So we had, so as far as I'm concerned, it was a huge number of people that vetted this for roughly, what, 3 years, David, I think? About 3 years. So when you tell me that you can walk in and fix this in, what, 60 days, whatever days you said, I have a problem with that. And I should have, everyone in this room should have a problem with that because these are the people that wrote it. And if you think that there's a flaw to it, then do the right thing and let it be vetted. I'm not talking about necessarily our committee. Yes, maybe those from our committee, but it truly needs to go back or needs to be vetted, whether we retained it. I have no problem retaining the bill, but the proper people come before us. Remember, the only people that testified was the Chief of Police Department. One of the questions that I asked that day, if the bail bondsman disagree or you have a disagreement, what is your recourse? And he said, contact the judge. So there is an avenue today for them that disagree. The other piece of that that came up was what percentage, all right? In talking and looking at some of the data here, you're probably talking about 2% maybe, and maybe not even that. So I'm still gonna say I have a problem with the, number one, I definitely have a problem with the amendment, but I haven't had a problem with the entire bill from day one that we had the bill. And we have had the conversation. I actually talked to another colleague here. Do you think that the commission might be meeting anytime soon? You know, are you guys defunct or whatever, which I couldn't really get an answer about that. I think it was because of COVID, they weren't meeting anymore. But I think there's a possibility that we can give this to a group of people that really can vet this issue that was brought before us by the chief of police. And mind you, the day that we had that hearing, I got home, played my voicemail, a commissioner. Unfortunately, he couldn't be there. He said, but we didn't know you even had that bill. So I struggle with the fact that nobody else testified outside of the chief of police. There's a problem. Because the stakeholders were many. And I would like to see the stakeholders there again. I would like to hear from rape and assault. I would like to hear from all the different groups that came out to testify and to work on this to make this a unique thing for pretrial. So with that said, I can't support the amendment, and I definitely did not support the bill. So.
Representative Catherine, I don't remember I don't have the list of every member who testified. I'm not excuse me, members, every member of the public who testified. I do know it was beyond, it was more than just, someone from the Chief of Police Association. And that testimony was in support of the underlying bill, which I think that the amendment dials that, when I say dials it back, I mean, this is less restrictive than the underlying Senate bill that came to us originally. So with the Chief of Police Association and whoever testified before the committee, this is not exactly this is again not the 72 hours. So, and now I'm not going to speak for members of the public that I consulted with because I don't want to put words in their mouth. But I did speak with more than one judge about this topic. That was done. I did speak with practicing attorneys in the state of New Hampshire on this, and there was input in that regard. I spoke with members of the court system. So they were consulted. I consulted with police officers, yes. There was a lot of consultations on my end with this, and I've been open about discussing this with anyone who wants to discuss the policies of how this should be drafted. And I would say the co-sponsor has a legal background as well of the amendment and is also a retired judge. So when I say that I work with, this is a Senate bill. Did I discuss this bill with members of the Senate? That's correct, I did. So I'm not saying that I have this super mind that's greater than a commission of put together, but there was a lot of consultation done in arriving at what is being presented for the community today. Even the amendment that was being floated around I believe last week or the week before, again, since that was out, the reason why there's some changes made is to take into consideration some of the thoughts, all right? Some thoughts. And just because someone makes a recommendation doesn't mean they're supportive of the entire amendment, but it did kind of, when I said it's a balancing act, that was done. And again, from a due process perspective, the person is being arrested if the state can demonstrate the burden of proof by clear and convincing evidence that they remain a threat to public safety. Then they're allowed. That is satisfying due process. That's consistent with the New Hampshire Supreme Court's prior decisions. They can make a determination, and that's involving life sentences. But that's the burden of proof. You can have a lower burden of proof if it doesn't involve a life sentence. But I am putting, I believe, the higher burden of proof is what's appropriate to have, and that's what this would. Yeah. So I don't believe anyone was excluded from the process again. I understand that people want more time, but I'm wondering. So recognized.
Okay. So I'm going to say that yes, they were excluded because you said that you had the conversations with so many people. Okay. This should have been something that there was a committee or detained so that everyone could hear what these people were saying. I don't believe that because you had a conversation with a judge, a lawyer, and whoever else you named, that's enough, giving what it took 2.5 years for people to do. And you're saying that you were able to get this done and reassess within a 60-day period, however long we had the bill. But I will say again that there's too many iffies about this this situation in terms of the documentation that was provided to us that the committee did. So I would like to see this go, be retained, and that we have the judge or the police officer or whoever, the citizen, anyone that cares about the system in terms of due process as well, and as well as our victims, come before us and give us that feedback. Because otherwise, I feel as though the 2.5 years that folks spent truly digging into this, and I look at notes like from Friday, October 18th, pretty much every month through October 20th of 2020, what they did to come up with this document and to come up with the recommendations. And if there's an issue, whether it's training or whatever it is that the chief of police seem to have with the bail bondsman, I think that's an issue that should be resolved. I don't think that should be resolved through law. I think that should be resolved through training. If I remember correctly, we had a bill about this additional training and any changes in the law and how quickly this stuff funnels down to the bail bonds. We went through all this, a couple months ago. So again, I'm gonna reach out to my colleagues and say that I would appreciate if we get together and retain this. And I think there'll be several people in this room, literally in this room today, that would probably not mind working on it. Because if there's a 2% and you're trying to change the law for 2% of the state of New Hampshire, I have a problem with that too.
Well, let me just clarify. When I say people are, no one's been deprived of offering their input. Again, there's been a public hearing scheduled, not just for this committee. This is a Senate bill. So there were multiple public hearings available for any member of the public to express themselves, whether they were a member of the bail commission or not. Now, the senators who sit on that bail commission, I'm not, Representative Welch, you might be, you tell me who those senators are.
On the commission?
Yes.
There was a senator before her.
Pardon?
There was a senator before her.
My point is that when we have multiple public hearings, it's my opinion, I don't feel that anyone's being excluded from the process. They're free to come testify before the committee and offer their opinion on what's being brought forward. And for the 2%, again, not every single person is going to be a changer. When you have people being arrested for domestic violence and they're literally being released within an hour or two of committing that offense, and they commit that same exact offense or even worse, that's under the current bail system that has been put into place. That is what we have happen. Now, does it happen all the time? No, but if you can make a demonstration to the court that type of offense, this person is likely to commit another violent crime against someone else, that's when they will be detained. It's not a per se, you are being held simply for your being charged. So I don't feel that there's a due process issue.
I believe a person is innocent until he's proven guilty. That's overall, that's the way our system works. I'm going to vote for this amendment, by the way, but I don't agree with you.
So, Representative Pantelakis?
Thank you, Mr. Chairman. I hope that you will not retain this bill. It's been long enough that this bail commission or any of these other people have been talking. We have to think of the people out there that can get hurt. If we have flaws in this amendment, we can correct it next year. Thank you.
Representative Boyd, Representative Hopper hasn't spoken, so let me.
I was just going to make a motion to move the question.
Second it.
Well, that's not an appropriate motion. I will accept that as a recommendation. I will say I know it's been going on for a little while. sorry that it's, but I don't want to cut off the discussion. People have their hands still raised. So I think after we have Representative Bournet, Representative Newman with their hands raised, and Representative Andrew Bolden. So I would like to at least recognize them to speak again, to respond to any of the comments. And then I believe after that, we'll then move the question.
I need to go to the restroom, so you wait till I come back.
And I did heard that
Time's up.
Representative Gathright is stepping out for a minute, and we will not move the question while she's doing that, despite her avid, strong disagreement with it. Representative Bournet, you are recognized.
Thank you, Mr. Chairman. Well, after reading the present law and your proposed amendment, I would like you to look at page 1, line 17. It looks like, according to the way I'm reading it, because one of the choices is detained, is that even now we don't need anything. We can retain anyone. Then we'll go down to section 3.
Representative Bournet, are you on the amendment that we represent?
I was on the amendment, yes. It's the same as it is in RSA. The choices are to be released on personal residence, released on condition of combination of conditions, retained, or temporarily retained. I would propose that since we are looking at this section of law, that C should probably be removed. Then we go down to paragraph 3, which is in the RSA, not in your amendment. I'll read it. Section 3, paragraph A. What?
Can you repeat the RSA?
Yes, this is back to the RSA. Paragraph A, safety of the public are the defendant. If a person is charged with any criminal offense, our offense listed in domestic violence are violating the protective order, etc. So by looking at the words any criminal offense, what has happened is with you listing a laundry list of offenses, you have narrowed the scope of the law, as well as making us revisit this section of law anytime we need to add another offense. So we can retain it and try and fix up all of RSA 598:2, or we can just let it go as it is. Thank you.
Thank you, Representative Bournet. The idea was to limit the scope of when it would apply to what type of offenses, and I don't, if it's not included in that list, it would fall outside. So I'm not aware of any violent crimes against a person that could be added to that list. If there is one, I would certainly support adding it. That's Representative Andrew Bolden.
Thank you, Mr. Chairman. I think it's more important that we get this right than get it done today. I've heard a couple of members on this committee say, well, maybe the language isn't quite right, but we can fix it later. We'll fix it next year. In fact, we have a few amendments which have been floated around, as the chairman stated via email. It's clear that there's a lot of discussion on this bill. We've got a bail commission that we should be looking for guidance from. Let's give ourselves some time to do this the right way, get language that we can not just agree on, but we can feel good about. I think retaining is the right way to go.
Representative Newman.
Thank you, Mr. Chair. I'll be brief. I also believe that someone who's charged with a crime, they're innocent until proven guilty. And I know there are egregious places where people got out and did bad things, and those are terrible and should be stopped. And I think they're entitled to due process. And under the current system of bail, under the current law, they have their due process served by I don't know if bail commissioners are members of the court, but they are certainly part of the government. And those people make decisions about whether they should be released or not, considering their dangerousness and threat to public safety and probably flight. And so I think that by removing the bail commissioners, and it was not explicit in the original bill that was going to be the effect of the bill, but it is explicit in this amendment that bail commissioners will not hear anybody who is charged with these particular offenses. And without that, they're denied due process in it, but the process they do get may fall in line with what the court decisions are on when only a court is involved. So my big problem is the removal of the bail commissioners completely from these crimes. And for that reason, I will not vote for this amendment. Thank you.
While waiting for a member to return to the room, Representative, I can inquire of a question. So, do you believe that a person's due process is being violated if they are not afforded an opportunity to be presented before a bail commissioner? You're muted.
If that's the question for me, I think that's how they get their due process today.
So if there's any circumstance where a person is not brought before a bail commissioner, like if they commit capital murder or homicide, in that scenario where they're not normally brought before a bail commissioner anyway, I mean, do you believe that that's a due process violation?
I don't know what the process is for who makes the decision when the police come to charge somebody with a crime. And the bail commissioner makes a judgment based on that. I don't know who the arbiter is at that point. And I think that perhaps it's the bail commissioner. I think that in those cases, the bail commissioner in the capital murder case would probably detain the person because of the conditions of that particular case. And my concern is that in those cases, people like that should be retained. But my fear is that if you completely eliminate the bail commissioners, everyone who is charged for any of these offenses, and especially the ones like domestic violence, that's a big one. But you can do very small amounts of inappropriate or unwarranted, I forget exactly the language, unwarranted touching. And it ends up that that all of those people would be retained. And I think that people underestimate, for the normal person who got into the criminal justice system under those kinds of circumstances, for them to spend the weekend in jail or be there for a period of 72 hours, especially if they are not very wealthy and need to have their job and everything. There's a lot of things that can happen to those people that shouldn't happen to them if they get what I think now is proper due process.
Seeing no, let's remind everyone, we want to have our videos on. Time the matter is with the question. So Green is in the room. If you are a member participating at home, is that everyone's cameras on?
Is everybody on? Yes or no?
On my screen, it's she's back.
Who?
She's back now. Seeing no further hands raised, the matter will now be put to question. If you are in support of adopting Amendment 2021-1549H, please say yay. If you are opposed, please say nay. The Clerk will now call the roll.
Vice Chairman Welch,
Aye.
Representative Bob Green,
Aye.
Representative Hopper,
Yes.
Representative Dennis Green,
Yes.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yes.
Representative Pratt, Representative Marston.
Yes.
The clerk votes yes. Representative Harriet Gathright,
No.
Representative Pantelakis,
yes,
Representative Massimilla,
No.
Representative Bourdonnais,
No.
Representative Muse,
No.
Representative Newman,
No.
Representative Andrew Bolden,
No.
Representative Conley,
No.
Representative Klein Knight,
No.
Representative Bradley,
Yes.
Chairman.
The chair votes yes.
Mr. Chair, the vote is 13 yay, 8 nay.
A vote of 13 yeas and 8 nays, the motion to adopt the amendment is passed. Considering the lengthy discussion we just had on whether to adopt the amendment, I believe it would be appropriate just to move the question. If anyone who hasn't spoken already wishes to speak, give them an opportunity to speak.
The question, because it's not in order.
That's correct. Representative, thank you, Representative Gabbard. Representative Rose, just to make a motion of ought to pass as amended.
Yes, Chairman, I would like to make a motion of ought to pass for Senate Bill 92
As
as
amended.
amended. Thank you.
And is that seconded?
A second.
The motion of ought to pass as amended has been seconded by Representative Green. Seeing no further hands raised, the matter will now be put to question. If you're in support of the motion of ought to pass as amended, please say yay. If you are opposed, please say nay.
Vice Chairman Welch,
No.
Representative Bob Green,
No.
Representative Hopper,
Yes.
Representative Dennis Green,
Yes.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
No.
Representative Pratt,
Yes.
Representative Marston,
Yes.
the clerk votes yes. Representative Harriet Gathright,
No.
Representative Pantelakis,
Muted, Barb.
yes,
Representative Massimilla,
No.
Representative Bourdonnais,
No.
Representative Newman,
No.
Representative Bolden, I'm sorry, Andrew Bolden,
Absolutely not.
Representative Conley,
No.
Representative Klein Knight,
No.
Representative Bradley,
No.
Chairman.
And the chair votes yes.
You missed Houston. Did you go?
I was,
My apologies, that was a mistake, I'm sorry. Representative Muse,
no.
Chairman.
The chair votes yes.
Mr. Chair, the vote is 11 nay, 9 yay. I'm sorry, 12. My apologies.
That's okay.
Muse is up further on the note. The vote is 12 nay, 9 yay.
I have a motion.
So this is 12 to 9.
12 to 9. No, yes,
So not to pass the amendment.
no, the
No, I
bill,
passed as amended.
Okay,
motion fails.
that's where we're at now.
Right.
Before I entertain any motion, we'll be in recess till 12:15.
Representative Gathright. I do have it, but he's further on the list, you know what I'm saying? So it was.
Yeah.
Yeah, she voted yes.
Was this the last bill that we're execing?
Like 296. 296 was passed in the Senate, but it was amended.
So it's SB.
HB 296. You want to meet the microphone since we're in recess?
You voted that?
No. How long are we in recess till, I think?
12:15.
Thank you.
Find out if there's a official note.
You were guy was out the evening. Correct. The last, okay, I can't keep you guys just like.
Really?
Well, I've never used crayons that I changed the name on the crayon. Red is red, blue is blue, green is green.
Did you bring in all those delicious looking sandwiches? Man, those look good. I didn't bring two, I had lots of breakfast on my way. So you actually didn't bring it up there. Oh.
I didn't bring food today because I thought we're done by 11.
Yeah, it's just Dave Boswell, World on 306 in the LOB. And we're dealing with Senate Bill 92. Is there a circle over on file over there? Senate Bill 92.
That's fine.
Oh. I drink that too. So both those, what judiciary I would think is quite busy. What about the other one?
Yeah, judiciary, we had over 50 bills this year. Budget. I think that's what you're going for building. I would have called it and.
Bring up this bill. So which one are we on? Which bill is it?
SB 92.
SB 92, isn't that a Senate bill?
Yeah.
Yeah, I've heard of that. Figured about what it was about.
I think he said he's doing something else too. Did he?
Oh, the one that we were talking about? I forget the name now too. Yeah, it's gonna be tea time.
Over there.
What's the other one you're looking at now? Was it 296?
Excuse me?
Which bill are we gonna be looking at now?
Just 92.
He said 296.
Hi, I'm checking with Mike right now. If you could hang in there another second.
I sure can.
Thank you.
I'm trying to get official note on this bill. I'm sure there's an impact.
192?
Yeah, I'm sure there's an impact on the county.
Oh, it is, because I'm on the same committee they're on.
Yeah.
And we just did the budget.
Yeah, he had no thoughts on that, that's it.
No official note.
Nope.
Thank you.
Okay, bye-bye.
No official note. The flying blind.
What's this one we're gonna look at this afternoon? 392 or 296?
92.
No, he just told me another bill. Did you hear him say we're gonna look at, I think it was 296, right?
Okay, that's one where the Senate changed. I think he's just gonna discuss maybe.
They're changed, but it was it a House bill, 296? I don't remember.
Yes. Because the Senate changed. We sent it to them.
All right.
And so we're concur, non-concur, or go to committee.
So is he gonna, can we get a copy of that?
They have no official note to clerk of.
Underlying fiscal bill, fiscal notes on the underlying bill. It's in here.
No. There's no, that's it. Doesn't say zero.
I literally looked at it.
You remember when we accept that one, 296?
I can. Was that it? I wrote the number down. I can't. There's the last one.
Trying to find them.
So the expenditures from the final bill have been determined.
I'm just checking my office.
There's no, I don't think there's any.
unknown cost to the judiciary, because I mean, it's hard to estimate those things anyhow.
Well, it's because it's mostly administrative work. It's mostly administrative work, not like cost for the
Oh,
county.
yeah,
So the idea is to increase the personnel.
but if you put somebody in the county jail, there's a cost.
Yes.
And the jail populations have gone down, and in some cases, they don't have enough correctional officers anyhow. So there's a whole lot of things that
The
go into
reason,
that.
yes, the reason why it's indeterminable is that when you have a new standard, you can't determine how many people would be held or not. I mean, you would be if you gave a number, you would be guessing. So I guess that you can come up with a million hypotheticals. And that's all you are. You would have to play it out. So it says indeterminable because they can't. If you're gonna hold 20 people, 30 people, 50 people, 100, you never know. It's not denying that there's an expenditure.
The county can't determine this.
So my understanding why it says indeterminable is because you would have to determine how many. If you had 4,000 of these type of charges, you have to determine of those 4,000, how many would be held. There's no way to determine that because there's no sample or no pool to pull it from. So even if they gave you a number, it would be a guess or an estimation. Any case you have is going to be very fact specific to why that person was held or not. So, and then when it comes to administrative tasks, like the court doing the administrative process, that's not normally put into a fiscal year. So that wouldn't be there. Now, hiring additional judges, I mean, we have two that passed in our budget. The other two that's been put in by the Senate, that hasn't passed officially, so you can't. It's not. I don't know if we should rely on those two judges staying. That just needs to change until it's passed. I mean, again, who knows what's going to change? So.
Do you know what they changed? When that bill?
What's that?
296.
So. What's finished business? I can tell you that it's changed. It was just a wording issue that it may have some complications. But we will now reconvene the Criminal Justice Public Safety Committee. All right, accept my apologies for the delay. See a few hands raised. Does the members have questions they wish to ask? Representative Pantelakis?
Mr. Chairman, I would like to know if I could make a motion on 92, Senate Bill 92.
Are you asking if there's going to be a motion?
If I could make a motion, or if there's whatever you want.
And Representative, well, before you make the Representative point, do you have a question?
Yes.
Question.
So you remember one of the statements I made earlier concerning your amendment, page 1, line 17?
Yes.
I went back to the 2018-2019 annotated criminal law, and that is not in there. I also checked the changes for 2019 and found out that section of law had not been amended. So I think that detained is a error that has crept in from paragraph 2 or section 2.
It says except as provided in paragraph 3 or 4. These are the options. So a person's not going to generally just be detained simply because they were arrested for no reason at all.
It's in the current law.
It isn't current. Oh, I'm being told, I thought it was in the current law. That's in the current law. So, all right. Representative Welch, you were looking at the blue.
That's the latest one.
Okay.
Yep.
It is in that book. It isn't in the previous book. So, and we did not make any changes because I just looked at all the changes for 2019 and 2018. There was no change to that section of 597.
Okay. No, I understand what you're saying. Representative Pantelakis, you wish to be recognized for a motion of.
Do we have to reconsider first?
Well, I don't know what a motion is. Representative Pantelakis, you are on mute.
I was wondering if I could make a motion. Senate Bill 92.
Excuse me, Representative Pantelakis, you faded out. Do you mind repeating that?
I wanted to know if I could make a motion on Senate Bill 92.
You are recognized to make a motion on Senate Bill 92.
I make a motion that we reconsider the previous vote on it.
Is that seconded by anyone?
I'll second.
Representative Bob Green, I appreciate you stepping up to second the motion.
Not allowed to.
Because you're a substitute, you're not allowed to. I learned that. Would any member, if you're willing, just,
I'll second.
we discussed it long enough, it didn't hurt to add to the discussion. That the motion to reconsider has been seconded by Representative Rose. Representative Pantelakis, do you wish to speak to your motion to reconsider?
I would like to make another motion after this to retain the bill.
And may I ask?
You don't have to do that.
I believe, so my understanding, we can.
If we can retain the bill without a motion to reconsider, that's what I'd like to do.
My understanding is that the bill can be retained without reconsidering the ought to pass as amendment.
Okay.
Whether the amendment or a subcommittee would be appointed, and as everyone said that they're so interested in working diligently to master the craft of this bill, that I'm sure that the subcommittee would make some changes, whether it would be amendment underlying the bill. But just remember, only one amendment could come forward. So,
am I able to recommend your amendment to retain it?
in the subcommittee, if it's retained, the subcommittee would be appointed. Representative Pantelakis, I see you take interest in said subcommittee. Yes, that amendment would still exist, and if you change one word in it, it would have to be a new amendment, but it wouldn't. It would still be something that can be discussed. I don't have a problem with that. So let me ask: is that if your intention is to retain the bill, would you wish to withdraw your motion for reconsideration and then be recognized for a motion to retain?
Yes.
And Representative Rose, would you withdraw the second as well?
Yes.
Representative Newman, did you have a question that you'd like to ask before Representative Pantelakis makes a motion? Representative Newman, you're so recognized. Great question.
Yes, I just want to comment the inquiry. What is the current status of the bill? What was the current status of the bill before the motion was made? Did we even vote on it? It failed.
There was a motion. There was a motion about to pass and to offer an amendment. The amendment passed by a vote, I believe.
Yes.
13 to 8, but then the ought to pass as amended failed. So now our option is we could retain it or expedite the legislature or reconsider.
Thank you for that clarification.
So Representative Pantelakis, do you wish to be recognized for a motion to retain?
Yes, I would. I make a motion to retain House Bill 92 so it can be.
Senate Bill 92. And is there someone, member wish to second the motion to retain? Representative Popper, you second the motion to retain Senate Bill 92. Representative Pantelakis, do you wish to speak to the motion?
Well, I just think that there needs to be changes in the law now. And I think if we committee together, we could work on it and change the changes that need to be.
It's unofficial note. Says they have something there, but they're gonna bring it over now.
So.
So there's gonna be.
We're in the voting mode now?
No. My understanding is the updated fiscal note that's gonna be delivered to us.
March. It was updated in March, and they're gonna bring it over.
On which bill?
This bill.
92?
Yeah.
So before we go to the voting mode, can I just inquire of a general question to the committee? Apparently, if there is an updated fiscal note, which we don't know.
That's gonna be a problem.
I have the fiscal note. All I'm asking is if there's an update, if there is an updated fiscal note, because I'm looking at the one that's on line. If there's an updated fiscal note, is that something that's gonna impact our decision?
What difference to make?
I don't wanna wait, we don't have to wait for it, it's not gonna have any impact. Then we would just go with motion to retain.
If we retain it, we can look at its entirety, not just what.
No, this is-
have done today.
This is the same thing that was that. They have more.
So my question was, would anyone's,
Mind change.
mind change or position change either way with an updated fiscal? Note? Right now, it's indeterminate. So if no one's mind's gonna change, then I'm not gonna wait for a potential update. If the answer is no, I think we can move the question. So
I move the question.
What is the motion?
there can't be a motion to move the question, but seeing no further hands raised, I don't have the cameras on, I hope so. The matter will now be put to question. If you're in support of the motion to retain, please say yay. If you're opposed, please say nay. Representative Gaffney, your
I
question.
just wanna know, are they online?
From what I can see on my computer, everyone has their camera on.
Okay. Thank you.
Yes.
Physical note can be taken up when we have the retained bill.
At this time, the clerk will now call the roll.
Vice Chairman Welch,
Yes.
Representative Bob Green,
Yes.
Representative Hopper,
Yes.
Representative Dennis Green,
Yes.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yay.
Representative Pratt,
Yes.
Representative Marston.
Yes.
The clerk votes yes. Representative Harry Gathright,
Yes.
Representative Pantelakis,
Yes.
Representative Massimilla,
Yes.
Representative Bourdonnais,
Yes.
Representative Muse,
Yes.
Representative Andrew Bowden,
Yes.
I'm sorry, Representative Newman,
Yes.
Representative Andrew Bowden,
Yes.
Representative Conley,
Yes.
Representative Klein Knight,
Yes.
Representative Bradley,
Yes.
Chairman.
Chair votes yes.
Mr. Chair, the vote is 21 yea, 0 nay.
By a vote of 21 yeas, 0 nays, the motion to retain is passed. The subcommittee. Representative Pantelakis, it seemed that you were interested in being on said subcommittee.
Yes.
Representative Welch, do you wish to be on said subcommittee?
Yeah, I'll do it.
Representative Conley, have your hand raised?
Yeah, I'll throw my name out there if you need someone, or if there's others who want to do it, I'll step down. But just saying, I'm expressing interest.
Well, let me ask this. If you wish to be in said subcommittee, please raise your hand.
John Burke said yes, next, they'd like to go.
Representative Burt is interested in being on the subcommittee.
So very.
Representative True, do you wish to be in the subcommittee?
Yes, sir.
Representative Bornay, your hand is raised.
Yes, I want to be on the committee.
Representative Gaffney, you wish to be on there as well? Representative Bradley, your hand is raised.
If there's room on the committee, I'd like to be as well.
Mr. Chairman, may I ask a question of you at the appropriate time?
You may be recognized for a question.
Thank you. Would it be appropriate to hold a full committee session of some kind? Because it seems like there's a lot of interest in getting it to a place we can support. And I don't recall seeing this many hands for any subcommittees last week.
Well, you're not sitting in the room, so it's a little more of a quiet appeal where I'm sitting. But just because you're not appointed to the subcommittee doesn't mean you can't participate in the hearing. It's just if the subcommittee makes any type of recommendation, there's no voting. There's no vote for that member as a member of the subcommittee.
Gotcha.
But anyone can sit in on the hearing. You can sit in the room, or whether it's on Zoom, whatever it is. There's no restriction on it. So when I'm putting members on it, it's because those members are going to have, obviously, you're going to have to work to accommodate each other. So let me just go through it. Right? Representative Gaffney, Representative Welch, Representative Pantelakis, Representative True, Representative Gathright, Representative Bradley, and Representative Palmer. I missed anyone? Boardman. Representative Boardman, correct?
Correct.
We'll add Representative Burt. That's up to me as well.
Mr. Chair, you'll be sending out an email.
Time and when?
No, you'll be sending out an email for who was on the committee.
We haven't met the other one. The other subcommittee, I haven't been notified.
It's the email went out. I'll make sure that you get it.
Okay. As long as it comes to my Gmail, I can read it. The others are all gone.
I'll make sure you get it. And Representative Welch, you want to chair that subcommittee?
I think Linda should chair it.
I think Laura should.
Oh. Whatever.
Just putting it to you. Would you like to chair it? If not, I'll do it. You know.
I just as soon do it.
I didn't hear.
You can always appoint Representative Burt.
Oh, God.
She would?
Yeah, I vote for John.
Laura?
Yes. Yes, I would.
Okay, thank you.
Representative Pantelakis, you've been appointed to chair that subcommittee.
Thank you.
Okay. At this time, we're going to close the executive session on Senate Bill 92. There's been one, so House Bill 296 passed this committee and amended in the Senate. They made a minor change to it. However, it had to do with the sending sharing intimate images. And what was changed was one line where the House bill that passed said either it was done with the intent to harass, annoy. There's another one. I'll pull it up right now.
If you can tell me what line that was once you get it, because I don't have my old bill with me. Does anybody have the old bill with them?
Which line?
We're getting there.
Line 14.
So the Senate amendment removes the terms annoy from the bill.
Where was it?
On Senate Bill 296.
What line?
If possible, can you read what it was? That
So
sentence.
Roman numeral 2. Roman numeral 2A is the section. I don't think on my screen. I have to keep going back to the amendment version.
I got the original, I mean, the amendment in front of me. I don't know what the old one said.
Two names.
No, it was changed, I think.
What does it say?
Coordinate, can you have someone that's online if they have the old one? Because I know we didn't bring out paperwork, we sent the red line.
So under 2A, it's the original, the bill that what we passed in the House says he or she sends by electronic device an unsolicited intimate image depicting sexually explicit conduct to the recipient with the intent to harass, annoy, or alarm the recipient. So that part is that's the language that we passed in the House. The word alarm or annoy has been removed. That's one part of it.
Is that the only change?
Bear with me one moment. So there is some concern. That's the only change that I see in it, but at the same time, there's some concern about that, how it will impact the sex offender registry, depending on the offense. So this has been brought to my attention by one of the stakeholders in the bill, that by changing it undermines or reduces the effectiveness of the bill. I like the original language better. I'm not clear why it was amended to not include annoy or alarm. If you look at the definition of harassment under RSAs, it includes annoying or alarming behavior. But I suppose that being annoying or alarming doesn't necessarily have to rise to harassment. So it seems to take it, at least the way I interpret it, narrows the application. Where the point being is that someone's sending an unsolicited nude image to another person. We all can be on the receiving end of that, and some of us may be consider that harassment, some of us may be alarmed by someone who do that. There can be different levels of impact on the person who receives it. I'm not clear why they were asked not to change it. This is my opinion. So I kind of like, the better. Representative True?
Thank you, Mr. Chair. In another world and a different time, whenever bills like this came over in other committees, we did a line-by-line change from committee research or committee clerk. I'm not saying that you missed anything, but it's always nice to be able to see these bills side by side, line by line, so they show what the changes are.
And in fairness to our committee assistant, he did send that to me. And I just, so in fairness to Brad Greenman, he did send that to the chair of the committee.
Okay.
And the chair has just located that in his email as we speak. We'll put that on myself.
So did he send it to us?
Question of the chair.
Recognized.
Thank you, Mr. Chairman. So they made the change to take it out. In essence, they're sending it back to us. Can we turn around and put it back in?
Well, at a committee conference, that's the challenge. So the two notations, I'll just read this. So the Senate version replaced he or she with the person. And the Senate version also removes that the person sending the image may have the intent to annoy or alarm the recipient. The sender would need to have the intent to harass the recipient. So that narrows it, but then it also changes Roman numeral 3. So the Senate version keeps the penalty for the first offense and subsequent offense the same. The Senate version also adds the person must have been convicted at the time the subsequent act in order to be guilty of a misdemeanor. So in order to have it to be a subsequent offense, you need a conviction. That's standard in the law already. So I don't know if that fixed anything that's not already in the law. I mentioned before, if you have to get charged with drunk driving 3 times in 3 days, they're all going to be first offenses if you don't have a prior conviction. So I believe the original bill that we passed, it would be the penalty would go up for a second or subsequent offense. This is currently due.
Just send it back to the committee.
So under our bill, if the first offense is a violation, I want it to be misdemeanor. It's a violation. The second offense is a misdemeanor. They reworded Roman numeral 3 to say, to clarify that you have to have already been convicted of the first offense, which that was my understanding of the law anyway, as written. I don't think it's a deviation from the policy as much as it's clarifying that, but you can't be, it's already the law, you can't be charged with subsequent offense by a prior conviction. I mean, you have to prove the prior conviction. Not sure why that was done, but that could be discussed during the committee conference as well. Is that true?
Thank you, Mr. Chair. Do we have any bills coming back from the Senate to this committee that the wise man once said you should always hold on to one committee accomplished bill in case we need to do massive changes on something else? Is this the one maybe we need?
Well, I believe there was another one that we had an issue with statute of limitations, and I'll tell you what that bill was. We discussed that. It was involving crimes against a minor. That one, I believe, we made it 6 years. The Senate reduced it to 3. I think the consensus of the committee was that we all wanted 6. So we would be having I'm going to ask that the committee of Congress be done on that bill. I just want to get you the bill number. I believe that's 239. So we passed this, that's with the tolling of the statute of limitations with six years after the 18th birthday for the alleged victim. The Senate reduced that to 3 years. I like the 6 years better. I wouldn't want the bill to not go. I think 3 is better than nothing, but I think 6 years is sufficient. I mean, you can't even buy cigarettes when you're 18. Never mind So that's just my,
Without seeing the line by line, is on 296, is annoy, removing annoy and alarm the major change?
that's the major change. I think the other sections is clarifying that is the law already.
Yeah.
It's more clarification purposes, but that's the major change. I read through the definition of harassment under the RSA. I was not convinced the change was necessary in so much as it's at least, because I don't think it necessarily annoying or alarming amounts to harassment, but it's part of the definition of harassment. If you are harassing someone, you're annoying or alarming them. That's part of it. Harassment is a little bit more to it. Again, Representative Pantelakis?
Yeah, but I think that should go to a committee conference and find out why they wanted the changes.
239, excuse me, 296. And we'll end on a positive note. Representative Klein Knight. Congratulations on House Bill 286, which was recently signed into law. I believe that's the first bill out of the committee this year that's been signed into law, so you get the prize for that. There's no official prize for that, but whatever it is, you got it.
I just, thank you, Chair, and thank you, members of the committee. It was obviously a very bipartisan effort since we couldn't have gone it that far without working together on that. So I can't wait to see what comes out of that. Thanks for everyone's commitment to that. Thanks, Chair.
Representative Pantelakis, any?
I just wanted to ask a question.
Yes.
Is it all right with you if I start Senate Bill 92 after September, say after the 15th of September, to have hearings?
Well, I'm not sure when the subcommittee is going to be able to meet. Again, that's something I would have to consult with the Speaker's office on. I don't know. While people are participating, members are participating remotely, there's only limited times. So we're not going to meet. This is the last meeting we're going to have. We've exec'd every bill that's been brought to us. We're not holding anything. So it's up to the chairs of those subcommittees to figure out when they can meet and make the schedule. So I just don't know when that can be done. If everyone meets in person, it would make it easier. But I'm not sure what that's up to the members of the committee, subcommittee to decide.
Generally, we don't meet during July and August.
And we don't in July and August. So.
Too hot.
Yeah.
So I know everyone was so eager to work on Senate Bill 92, so I appreciate everyone wanting to get started. But
Yeah, I thought that usually comes from the speaker also, that he tells people when they may start.
yes, they'll be correct. Representative True?
On a lighter note, I was reading on the World Wide Web today that today is Dennis Green's birthday, and he's 51 years old. So I want you to know that if you read it online, you know it's true.
It's the wrong Dennis Green.
I didn't get Dennis anything.
Would you like to swap?
Before we
No
adjourn,
comment.
do any members have any other questions or comments that we need to address before we wrap things up? You good?
I have a question.
Representative Biafra?
One that you were just on in section 3. Can you read to me one more time what the old one says?
The original version that passed in the House says any person who violates this provision of this section shall be guilty of a violation for the first offense and a misdemeanor for a second or subsequent offense. The Senate version says, any person who violates the provisions of this section shall be guilty of a violation for the first offense and a misdemeanor for the second or subsequent offense if the court finds that the person has previously been convicted of a violation of this section at the time of the subsequent act. So the Senate language is clarifying that in order to have a subsequent offense, or to be considered a second or subsequent offense, you must have already been convicted of the act at the time the second or subsequent offense occurred. That's my understanding of the law. I brought up, not to rehash Senate Bill 92, but I brought up the drunk driving situation. The person had 5 number 1, we charged with 5 offenses, are all considered first offenses. That's because there's never been a conviction. So I understand the law to not require it to be written that way. It doesn't change the operation of it. It's not a subsequent offense without a prior conviction. So,
Yeah.
but that's
Okay. That's why.
If I'm wrong,
I
I'm
didn't see
wrong.
what the difference was there or why they needed to expound on.
but also by now putting it there, not having it everywhere else. I don't know. Once when you write it there, it's going to be in the law, and I don't know if you're going to keep doing that every time we draft stuff. Every time we draft a provision as a subsequent offense or a second, third, fourth offense, must we address, you must have been already convicted? I mean, it sounds like a lot of, I think you know where I'm going with that. But anyway, I will be moving for media conference. I don't believe there's any other bills out there that we haven't discussed in committee already. Thank you, everyone. That finishes year 1 for us, and we will be adjourned.